Hello, good day. This is the continuation of the void or inexistent contracts for the chapter 9. So let's start. The article 1416 states that when the agreement is not illegal per se but is merely prohibited, and the prohibition by the law is designed for the protection of the plaintiff, he may, if public policy is thereby enhanced, recover what he has paid or delivered. So the further, so we have to have a further explanation to that. Article 1416 is another exception to the rule that where both parties are in pari delicto, they will be left where they are without relief. Recovery is permitted provided with this enumeration. The first one is the agreement is not illegal per se but is merely prohibited. The second one is the prohibition is designed for the protection of the plaintiff. And the third is the public policy will be enhanced by allowing the plaintiff to recover what he has paid or delivered. So for the further elaboration for these enumeration is the first one is a land sold in a violation of constitutional prohibition against the transfer of lands to aliens may be recovered. The public policy to conserve lands for the Filipinos will be defeated and its continued violation sanctioned if instead of setting the contract aside and ordering the restoration of the property, the general rule on pari delicto will be applied and the parties will not be permitted to resort to another transaction for the purpose of disguising the transfer in violation of the Constitution. Second is the principle of pari delicta is not applicable to a homestead which has been illegally sold within the prohibited period of 5 years in violation of the homestead law. The policy of the law is to give land to a family for home and cultivation. Consequently, the law allows the homesteader or free patent holder to reacquire the land even it has been sold within the prohibited period. Third is the Section 122 of the Public Land Act has been amended by the Section 11, Article 14 of the 1973 Constitution by reducing to only 24 hectares the maximum area of public land that can be acquired by an individual. It follows that such is also the maximum area of land acquired under the Act that could be transferred by any purchaser, patentee, or homesteader. A conveyance of public land previously acquired from the government of more than 24 hectares is not in void, but it's not illegal per se. The constitutional limitation is malum prohibitum, only not malum in se. Hence, Article 1416 is applicable. So, another additional law for this is the contract illegal per se and contract against the public policy distinguish. So, an act or contract that is illegal per se is one that by universally recognized standards is inherently or by its very nature improper, immoral, or contrary to the good conscience. On the other hand, what is contrary to public policy, like public interest, whether expressed in constitution or in any statute or official declaration of the duly constituted authorities or events from the situation or circumstances of the time concerned, is something dictated by the condition obtaining within each country or nation. So the next article is the Article 1417, where it states that when the price of any article or commodity is determined by the statute or by authority of law, any person paying any amount in excess of the maximum price allowed may recover such excess. For the further explanation for that is the recovery of amount paid in excess of ceiling price. A statute fixing the maximum price of any article or commodity is usually known as the ceiling law. It can also be determined by authority of law, as by executive order of the president. Its purpose is to curb the evils of the profiteering or black marketing. Next is the Article 1418, where it states that when the law fixes or authorizes the fixing of the maximum number of hours of labor, then a contract is entered into whereby a laborer undertakes to work longer than the maximum thus fixed. He may be demand additional compensation for service rendered beyond the time limit. The recovery of additional compensation for service rendered beyond time limit. In the Presidential Decree number 442, as amended, otherwise known as the Labor Code, sets forth that the normal hours of work of any employee shall not exceed 8 hours a day. So the labor code applies to employees in all establishments and undertakings, whether for profit or not, but not to the government employees, managerial employees, field personnel, members of the family of the employer who are dependent upon him for support, domestic helpers, person in personal service of another, and workers who are paid by the results. So the next article is the 1419, where it states that when the law sets or authorizes the setting of a minimum wage for laborers, and a contract is agreed upon by which a laborer accepts a lower wage, he shall be entitled to recover the deficiency. So the recovery of the maximum wage less than the minimum fixed. If an employee or worker receives less than the minimum wage rate, he can still recover the deficiency with legal interest, and the employer shall be criminally liable. The Article 1420 states in case of a divisible contract, if the illegal terms can be separated from the legal ones, the latter may be enforced. Further explanation for that is the effect of illegality where the contract is indivisible or divisible. So, when the contract is indivisible, the consideration is the entire and the single contract is indivisible, so that if part of such consideration is illegal, the whole contract is void and unenforceable. So when the contract is divisible or severable, that is, the consideration is made up of several parts, and the illegal ones can be separated from the legal portions without doing violence to the intention of the parties. The latter may be enforced. This rule, however, is subject to the contrary intention of the parties. So the visible contract distinguished from divisible obligation. It must be noted that the Article 1420 speaks of a divisible contract and not of a divisible obligation. The test of the former is the divisibility of its cause, while the latter is the susceptibility of partial fulfillment. The former therefore refers to the cause, while the latter to the prestation or object. Next article is the 1421, states that the defense of the illegality of contract is not available to the third persons whose interests are not directly affected. So the person entitled to raise defense of illegality or nullity in avoidable Article 1397 and enforceable contracts Article 1408 Third persons are not allowed to bring an action to annul or to assail, as the case may be, said contracts. If the contract is illegal or void, however, even a third person may avail of the defense of illegality or set up its illegality as long as his interest is directly affected by the contract. The last article is the Article 1422, where it states that a contract which is direct result of a previous illegal contract is also void and inexistent. Void contract cannot be novated. This provision is based on the requisite of a valid novation. An illegal contract is void and inexistent and cannot therefore give rise to a valid contract. For example, a contract of repurchase is dependent on the validity of the contract of sale. If the latter itself void because the seller is not the owner, the former is also void because it presupposes a valid contract of sale between the same parties. One cannot repurchase only what he has previously sold.